On behalf of the Issam Institute for Public Policy and International Affairs, I'd like to welcome everybody to our first in a lecture series in international affairs here at the American University in Beirut. We're very pleased to be launching not just this lecture series for this academic year, but also the first of the presentation will be the first from a working series paper on topical issues related to international affairs, international law, the United Nations in the region, things that are relevant to the region. And I'll talk about this in just a second. The Issam Institute has launched this working paper series with two main goals in mind. The first, of course, is simply to make sense of the world around us, and in particular the tension between the principles of the international order established following World War II and as embodied in the United Nations Charter, on the one hand, and the new global security paradigm of the post-Cold War, and in particular the post-September 11, 2001 period. There's a clear tension between these two areas, and we in particular in this region have been feeling the impact of this tension with global wars that have come to this region, whether it's in Iraq, Palestine, Lebanon, Sudan, and other parts of the region itself. So on the one hand, we need to make sense of what's going on in this region and how the international order is being reflected here in this region. On the other hand, the second main goal of the series is to address the specific problems that illustrate this tension and offer some guidance to decision makers and to the general public in the form of some policy recommendations. So we both want to try to understand what's going on, but also try as much as possible to offer some kind of recommendations or suggestions, and certainly for discussion. I mean, it's not going to be something that's earth-shattering, but it's going to be issues that are being raised and points that are going to be made for discussion. And I think today, the choice of today's presenter, in particular, to launch this series, is both what she represents and the topic that she's going to be addressing is an ideal place to start today. Noura Erakat embodies the scholar-activist approach to both politics and academia. And she's engaged in both the scholarly side of politics, but also in the implementation part, in actual human rights activism, in consultancies with various NGOs, and even with the US government at various stages. So I'd like to welcome Noura Erakat, who, as I said, teaches international human rights law at Georgetown University Law Center. She's also been working as a Middle East advisor to the US Congressman Dennis Kucinich, who's some of you may know is probably one of the very few progressive voices in Congress in the United States, as well as the Legal Counsel to the Congressional Subcommittee. We're very pleased to have her. I'd also like to welcome our two formal discussants. After Noura gives her presentation, we're going to have two formal discussants who will just give some commentary on the paper itself, the full paper, which will be available. Her working paper will be available on the Issam Institute website in the coming days. So for those of you that are interested in the paper itself, it will be available for everybody to download and to look at. The two discussants, just I'll briefly introduce for now, Professor Coralie Hindawi, who's a colleague of mine at the Department of Public Studies and Public Administration, and whose specialty is in international law. And as well, the second discussant is Ms. Nadine Houri, who some of you know as the Human Rights Watch Director here in Lebanon, and is a lawyer and is a specialist as well in international humanitarian laws. So the two of them will be giving formal comments, responding to or critiquing and beginning the discussion and conversation with Noura Erakat's initial presentation. So the initial presentation will be about 30 minutes long or so. She'll be giving at the podium, followed by two discussants, each one of which will be about 10 minutes long, and then we'll have another 30 or 40 minutes for general discussion by the audience. So please help me welcome Ms. Noura Erakat.
I want to thank the Issam Institute for their faith in me and their institutional support through this project, and especially to Karim Maqdisi for his direction throughout the process, and to Ramzi Houri for his wonderful research throughout. And as he can attest, I'm very demanding in terms of the research that we needed. So thank you so much to the Institute, to Karim, to Ramzi, and to all the wonderful people at IFI who have made this an absolute pleasure, especially coming back. So, as the title of my lecture suggests, my paper examines the legality of the Gaza blockade in international law. My inquiry did not begin with the Gaza blockade, however. It began with a concern for the dynamism of international law, and particularly how events in the Middle East and the international response to those events, as personified by the United Nations, have shaped international law as we know it today. Perhaps what is most frustrating about the law is that aside from commerce and trade, little of it is enforceable. In fact, the whole of the humanitarian and human rights regime is one that is built on voluntary consensus. No state actually, has been forced to sign or ratify a treaty. And certainly the commitment to certain principles are not permanent. Customary law, which is the strongest in the international legal field, because it takes effect when there is no binding treaty, is based on opinio juris and state practice. Opinio juris reflects what states believe to be true, and state practice reflects what states do to demonstrate that belief. So, for example, if today the 5 permanent members of the Security Council decided that it was legal to deny medical relief to their prisoners of war, and they did it for a long enough and consistent enough time, they disrupt the consensus that underpins the law. They undermine the Second Geneva Convention, which regulates the treatment of combatants. And if they influence other states to do the same, then they will certainly have worked to shift the meaning of international law despite its written and ratified status. So what happens when the world's superpower and its most controversial ally in the Middle East decide that the existing legal meaning of self-defense does not suit them? In the case of the US and Israel, they attempt to change the legal definition through practice. And just a brief note on self-defense. 3 points. The first, when I'm discussing self-defense here, I'm discussing its legal definition as enshrined by customary law, as well as its charter definition in Article 51 and Article 2.4. So I'm not talking about the self-defense that we may understand either in a domestic situation or in a commonplace situation. Second, at present, the scope of self-defense is not without controversy. It's not as if only Israel and the US are contesting its legal definition. It is, in fact, fluid. And so, where there exist several interpretations of it, and those interpretations have become even more relevant since the US described its attack on Iraq in 2003 as a preemptive attack in self-defense, legal under both the Charter and customary law. And since September 11th, the world's response to the Al-Qaeda attacks on the US redefined Article 51 altogether by affirming that an armed attack, which in its charter form must be imputable to a foreign state, need not be imputable because non-state actors can commit an attack. In the ratification of UN Security Council Resolutions 1368 and 1373, which I'll get to later, but made it so that even non-state actors can commit an armed attack within the meaning of Article 51. And third, in the case of Israel, the challenge involves 2 things. First, not only can non-state actors commit attacks constituting an armed attack within the Charter meaning, but that those attacks can be committed by a population living under its occupation. And I'll get to why this blurs the existing legal standard. Secondly, regardless of the applicability of the laws of occupation, which regulates the use of force in occupied territory, Israel insists that it can engage in war against a population already living under its occupation, or an international armed conflict, and those attempts to shift the definition of what type of force can be used against the occupied population or occupied territory is a deliberate and conscious attempt on the part of Israel to challenge the existing legal order. Consider the statement made by the head of the International Law Division of the Israel Military Advocate General. If you do something for long enough, the world will accept it. The whole of international law is now based on the notion that an act that is forbidden today becomes permissible if executed by enough countries. International law progresses through violations. We invented the targeted assassination thesis, and we had to push it. At first, there were protrusions that made it hard to insert easily into legal molds. 8 years later, it is at the center of the bound of legitimacy. In this paper, I examined Israel's attempt to shift the meaning of self-defense as well as the permissible use of force during an occupation. And I used the Gaza Blockade as a case study. I scrutinized the United Nations Security Council's role in responding to this critical attempt to shape the law, as Karim mentioned, to make this of practical relevance. How has the United Nations responded to this, and how has that response either perpetuated this confusion, undermined the law, resisted the attempt to shift, or colluded with this attempt to shift? And as you can imagine, I find that the UN, as embodied by the UN Security Council, because of its enforcement authority, has actually, at best, not resisted the attempt, and at worst, colluded with the attempt. And to demonstrate the UN Security Council's failure to uphold the rule of law and address what may be a crisis of legitimacy, I will begin by providing a background of the Gaza Strip leading to the imposition of the blockade, which I'll make the shortest because I imagine that this is what we should all know best. Second, I will show that the blockade is illegal pursuant to international humanitarian law. Third, I will demonstrate how the UN is in violation of its own charter because of the Security Council's failure to respect international law and the grotesque discrepancy between its handling of the crisis in Gaza as compared with other international case studies. Such a discrepancy renders the situation in Gaza a legal black hole, or might as opposed to right is actually the strongest force. I conclude by making recommendations to the UN to address such failure, as well as to posit questions for future research, which I may probably not share here. So to begin with the first section, just a quick background that is of utmost relevance is the background on the Gaza Strip. As we know, it's the westernmost part of historic Palestine that was supposed to comprise part of the Palestinian state pursuant to UN Security Council Resolution 181. In 1948, it came under Egyptian control. In 1967, it became occupied by Israel. And this discussion of Israel's occupation, by the way, is very interesting and relevant, and I'll leave it to question and answer if you want to discuss it. But up until now, Israel contests the applicability of the Fourth Geneva Convention, which governs occupation, and its applicability to Gaza, because it contests whether it's occupied territory in toto. So moving on, jumping ahead very fast, is to 2005. Israel's unilateral disengagement in 2005 marked the shift when Israel declared to the world that it was no longer an occupying power, and now it was dealing with an independent entity, notwithstanding the fact that it maintained a substantive amount of control of the Gaza Strip, and that control becomes the crux of a legal analysis of whether the occupation persists or not. Moving on to January 2006, despite a historic stance against Oslo, as well as the Palestinian Authority, Hamas participates in the election. It wins an electoral victory in parliament and assumes power. In response, there's a world international backlash from the US, the European Union, as well as Israel, protesting this democratic election, and they henceforth begin to support Hamas's counterpart, Fatah, within Gaza, which leads in June 2007 to what many have described as a preemptive coup on the part of Hamas. In response to that ouster of Fatah from Gaza, Israel imposes a debilitating blockade that we know, that we continue, unfortunately, to witness today. A blockade that cuts off all basic goods, where Israel has sealed the 5 crossings between it and Gaza, as well as between Gaza and the world, save for its crossing with Egypt, which Egypt seals, which include Erez, Karmi, Sufa, Nahal Oz, and Kerem Shalom. It has also imposed a naval blockade and limited fuel and electricity into the Strip, and Israel's policies have amounted to an almost complete prohibition on the movement of people into and out of the Strip, with few exceptions, even for the ill seeking medical treatment. And the devastating impact on Gaza's 1.5 million Palestinian residents has been well documented and defined as a humanitarian crisis by a broad range of international human rights and humanitarian aid organizations. I will not discuss those exact grievances, whether or not this constitutes a violation of Article 33 prohibiting collective punishment, whether or not this abrogates Israel's duty to provide for those civilians under its occupation. My concern is that the blockade, however regulated, even in the most humane way, would still be illegal. And so here is the reason why. If Israel remains in occupying power in the Gaza Strip, the laws of occupation continue to apply. If the laws of occupation continue to apply, there's 2 things that happen. The first is that legal self-defense has already been triggered and can't be triggered again. And the second is that Israel has the right to use force in the territory, but that right is limited to law enforcement or policing of the territory, and not to hostile use of force as would be permissible in war. Therefore, Israel cannot declare war on the occupied territory, and it certainly prohibits the imposition of a blockade, which under international law, under customary law, amounts to war. So, Israel challenges this formulation in two ways. First, it says that it is no longer occupying Gaza since its 2005 withdrawal. And second, it argues that even if an occupation did exist in the West Bank, even in the West Bank, not just Gaza where it says that the occupation has ceased to exist, that would not alter that Israel is allowed to exercise force permissible during an international armed conflict. And so let me begin with the first question of occupation. In international law, occupation hinges on something called effective control, which is derived from Article 42 of the 1907 Hague Regulations. The effective control test does not require the military presence of the occupier throughout the territory, but rather tests the extent to which the occupying power, through its military presence, is exerting effective control over the territory and limiting the right to self-determination of the occupied population. The controlling element in this test is whether a belligerent has established its authority and has the ability to exercise it. Consider that in its disengagement plan, in the plan itself, Israel reserved the right to use force against Palestinians living in Gaza in the name of preventive and reactive self-defense. And since 2005, Israel has conducted several military operations in the Strip in the name of such self-defense. Consider also that Israel has maintained a control over its airspace, its seaports, its telecommunication network, its electromagnetic sphere, its tax revenue distribution, and its population registry. Finally, Israel has complete control of Palestinian movement as it controls its 5 border crossings with Gaza and therefore the ingress and egress of all of its goods and people. The confluence of its ongoing control, its continuing military operations, as well as its capacity to redeploy its troops within a reasonable time, demonstrate that Israel remains in effective control of the Gaza Strip. There exists general international consensus affirming Gaza's ongoing status as occupied territory and Israel's status as an occupying power. And accordingly, the laws of occupation remain in force. That's one issue. The other issue, which I will cover in much detail, is the legality of the way, is not the legality of the way in which Israel has imposed its blockade. As I mentioned earlier, the manner in which the blockade is imposed is not as relevant, although it remains a very critical part of the equation, and it's what the UN High Commissioner Navi Pillai, as well as the Special Rapporteur to Occupied Territories, Richard Fall, have used to define the illegality of the blockade. But consider that whether or not Israel is an occupying power, it has several enumerated obligations to protect the civilian population living under its siege, regardless of occupied status. And so I won't discuss those here, but you can see that in the paper. I'll leave that for maybe the discussants if they want to bring up also. Instead, what I seek to demonstrate is Israel's deliberate attempt to contravene, to deliberately shift what the established legal order is, and to shift the meaning of self-defense, as well as the permissible use of force in occupied territory. And to examine this attempt, I look at the permissible use of force afforded an occupying power during an occupation, while the ongoing use of force, such as that applied during a belligerent occupation, as well as an international armed conflict, is regulated by jus in bello. The initiation of force, or what we know as the right to use force, is regulated by jus ad bellum. Jus ad bellum refers to the prohibitions on the use of force in the UN Charter, Article 2.4, and its sole exception found in Article 51, which permits self-defense in the case of an armed attack. Once initiated, jus in bello, or the legal framework regulating the permissible use of force, is triggered. Such law, the latter, includes both the laws of war as well as the laws of occupation. And so the distinction is one solely within jus in bello. The laws of war are based on a crude balance between humanitarian concerns and military advantage. And as defined by the Nuremberg trials, military efficiency allows a belligerent to expend, quote, any amount and kind of force to compel the complete submission of the enemy, so long as the destruction of life and property is not done for revenge or a lust to kill. The permissible use of force during war is therefore very expansive. In contrast, during an occupation, and pursuant to the laws of occupation derived from Article 43 of the Hague Regulations, the use of force is much more limited. Article 43 imposes a duty upon the occupying power to maintain law and order in the territories and places the responsibility for a breach in law and order upon the occupying power. Accordingly, the permissible use of force during an occupation is that which is permissible during law enforcement operations. And so according to Marco Sassoli, police operations are subject to many more restrictions than hostilities. To mention but one example, force may be used against civilians only as a last resort after nonviolent means have proved unsuccessful in maintaining law and order. As for the use of firearms, it is an extreme measure in police operations, while it is normal against combatants in hostilities. The existing legal order prohibits an occupying power from initiating force against its occupied territory. Because where there exists a belligerent occupation, an armed attack has already occurred in response to which the belligerent initiated force. And here we discussed that initiation of force was the Six-Day War in 1967. Therefore, Article 51, self-defense, is no longer available to Israel because the time when self-defense could be invoked has passed, the resort to force has already occurred, and the situation is now governed by a different regime of international humanitarian law. To assert otherwise is arguably unfair, as it affords the occupying power both the right to use police force in a territory, and when it feels that those powers are inadequate, it expands its use of force by invoking a broader right to self-defense. Moreover, an occupying power should not be able to justify its use of military force in response to a breakdown in order within occupied territory because it is responsible for maintaining that order in the first place. In doing so, or in doing otherwise, The occupying power would be conflating and rendering useless two otherwise distinct legal regimes of jus in bello and jus et bello. Accordingly, as an occupying power, Israel can protect itself and its citizens from attacks conducted by Hamas. But as a matter of law, it must do this as an exercise of its right to police the occupied territories and not as a right to self-defense. Ian Scobie comments that Israel can indeed take defensive measures in response to threats, but that they need not be justified as measures taken in self-defense under Article 51 of the Charter because, quote, to equate the two is simply to confuse the legal with the linguistic denotation of the term defense. Just as negligence in law does not mean carelessness, but rather refers to an elaborate doctrinal structure, so self-defense refers to a complex doctrine that has a much more restricted scope than ordinary notions of defense. Unfortunately, this alliance between legitimate security concerns and self-defense is embedded in Israel's justification. Israel's deliberate use of legal self-defense as a justification both challenges the legal order as well as seeks to avoid the constraints of international humanitarian law upon an occupying power. And this attempt fits squarely within an ongoing debate on the parameters of self-defense that began at least since the United States attack on Iraq in the early 1990s. The debate explores whether the legal definition of self-defense should be subject to the broad framework of customary international law, which refers to the Caroline incident, and there's 3 factors, and we can discuss that during Q&A, or alternatively within the narrow scope of self-defense as defined by the UN Charter, whether it can be invoked against a non-state entity, especially in an age where non-state actors have conducted international attacks, and now an even more relevant argument that international law has no role for a state when it decides when it needs to act in self-defense. In regard to this case study in particular, Israel has cited UN Security Council's resolutions 1368 and 1373. The Security Council passed these resolutions in direct response to al-Qaeda's attack on the United States on September 11th. And the resolution affirms that terrorist acts amount to threats to international peace and security and therefore trigger the inherent right of individual or collective self-defense as recognized by the United Nations Charter. Israel has deliberately worked to first cast all of Palestinian violence or resistance or any acts of Palestinian militant activity as terrorist acts. Secondly, to frame those acts as amounting to armed attacks. And thirdly, to argue that some such armed attack triggers Article 51. Irrespective of the occupied status of the West Bank or the Gaza Strip or East Jerusalem. In the Israeli Supreme Court decision, the Public Committee Against Torture in Israel versus the Government of Israel, the state argued that notwithstanding existing legal debate, quote, there can be no doubt that the assault of terrorism against Israel fits the definition of an armed attack, effectively permitting Israel to use military force against those entities. Israeli officials continue that the laws of war can therefore apply to both occupied territory and to territory which is not occupied as long as armed conflict is taking place on it, and that the permissible use of force is not limited. The Israeli High Court of Justice affirmed this stance in at least 3 of its Supreme Court decisions. Still, in the 2004 advisory opinion of the International Court of Justice exploring the legal consequences on the construction of a wall in the occupied Palestinian territory, the ICJ, which is arguably the highest form of justice in the world, or the world court, reasoned that Article 51 contemplates an armed attack of one state, against another state, and, quote, Israel does not claim that the attacks against it are imputable to a foreign state. Moreover, the court held that because the threat to Israel originates within and not outside of the occupied West Bank, that the situation is thus different than that contemplated by the Security Council in Resolutions 1368 and 73. The court makes 2 critical distinctions here. First, that a non-state entity cannot trigger Article 51 of self-defense. This statement, this first one, is very controversial and has not been accepted by many legal scholars. But the second, that because the armed attack originated within occupied territory, presumably where the laws of occupation apply, that distinguishes it from an attack committed by Al-Qaeda against the US. And as such, 1368 and 1373 cannot be applied to Israel and its territories. Despite the ICJ's clarity on this matter, Israel continues to insist that it's exercising its legal right to self-defense. And since 2005, Israel has made this less confusing by saying that Gaza is not occupied altogether, and insisted that the occupation came to an end and therefore a new regime exists. Even so, Israel's legal position amounts to a challenge of the legal order because, as demonstrated above, Gaza remains occupied as a matter of law. And Israel's insistence that Gaza is occupied, despite near international consensus to the contrary, as well as its insistence that it can use force beyond that permissible for law enforcement, irrespective of occupied status, renders the civilian population under its occupation, as well as civilian populations under occupation for years to come, incredibly vulnerable. And this is best said by, oh, that would have helped you, but this is the ICJ decision. This is best articulated by Professor Georgetown Erakat of UC Hastings, as well as a number of his students who wrote a comprehensive law review piece on Operation Cast Lead, when he wrote, "It forces the people of the Gaza Strip to face one of the most powerful militaries in the world without the benefit either of its own military or of any realistic means to acquire the means to defend itself. Thus, they believe that Israel's attempt to transform international humanitarian law in this respect should be firmly resisted, and that its military operations in the Strip should be continued to be evaluated by law enforcement standards." So, that brings us to who can resist the challenge to Israel's attempts and actually continue to uphold that law enforcement standards apply. And here I shift my gaze to the UN Security Council, which is the only body within the UN that has enforcement authority, and it has several means to exercise that authority under several of the UN Charter enumerated provisions. But I argue, and I'll get to this, that the UNC has failed to uphold the rule of law in the case of the blockade in several ways. First, it's applied the law unequally, and to apply it unequally is going to be natural to any political body, as is the UN, despite its mandate to uphold the law because of its political nature. But what I'm concerned with here is the discrepancy in that application. The second is an inadequate scrutiny of the situation in Gaza compared to the other cases. And the third is that the treatment of the blockade has been consistently political at the expense of the law. Here's a quote from former UN Secretary General Kofi Annan to underpin this commitment to the rule of law. But just to get to those 3 points, on the first of discrepancy, the Security Council exercised its Chapter 7 authority to authorize the use of force and impose sanctions in numerous cases since its establishment. I look at 2 cases specifically where a humanitarian crisis existed, namely in Bosnia-Herzegovina and in Somalia. In the case of Bosnia-Herzegovina, during the breakup of the former Socialist Republic of Yugoslavia, Serbian forces applied force amounting to war crimes in its former territory, a newly autonomous state. In response to devastating events in the war-torn republic, the Security Council passed 9 resolutions between September 25, 1991 and May 30, 1992. In Resolution 757, the Security Council, that would have helped also. In Resolution 757, the Security Council affirmed the UN's primary role of maintaining international peace and security and declared that the situation in Bosnia and Herzegovina and other parts of the former Yugoslavia constitute a threat to international peace and security, and invoked Chapter 7 authority to address the situation, and here's the text for that. Pursuant to that authority, the Security Council established an embargo on the former Yugoslavia, prohibiting a broad range of activities from the inclusion of Yugoslavia in international sporting events to a ban on any flights into and out of or even over Yugoslavia. Resolution 757 also forcefully demands for the unimpeded delivery of aid and establishes security zones to that effect. Only a few months later, in October 1992, the Security Council passed Resolution 781 and effectively imposed a ban on military flights in Bosnia and Herzegovina's airspace in order to ensure the delivery of humanitarian aid and the cessation of hostilities in the territory, thus highlighting the extent of Security Council authority to intervene in a case where a humanitarian crisis is rendered during wartime or warfare. The Security Council acted with similar urgency and force in the face of the humanitarian crisis in Somalia during its civil war. It passed 6 resolutions relating to the crisis and invoked its Chapter 7 authority twice in order to ensure the delivery of humanitarian relief throughout Somalia. Still, all 6 resolutions mention the humanitarian crisis and the urgent need for its redress. In addition to its Chapter 7 authorities, Resolutions 733 and 794 are also noteworthy for their reference to an affirmation of international law. And I don't know if you can read that, but I'll read a relevant section where it affirms international law in its deliberations, even in its political deliberations, when it says that it strongly condemns all violations of international humanitarian law occurring in Somalia, including, in particular, the deliberate impeding of the delivery of food and medical supplies essential for the survival of the civilian population, and affirms that those who commit or order the commission of such acts will be held individually responsible in respect to such acts. The language of 794 makes several strides in the furtherance of international humanitarian law. It affirms its inviolability. It lists with specificity those acts that rise to an abrogation of the law, and it holds the perpetrators of those violations that they will be held individually responsible and liable for war crimes. This response demonstrates just the extent of the discrepancy to its response to Gaza. And so here, consider that in a span of 8 months, that the Security Council passed 9 Security Council resolutions in response to Bosnia and Herzegovina. In a span of 1 year, it passed 6 resolutions in response to the case of the humanitarian crisis and war in Somalia. But in the case of the Middle East between 2005 and the present, notwithstanding unilateral disengagement, notwithstanding a devastating war that rendered 1,400 Palestinian civilians, at least not all civilians, but 3/4 of whom are civilians, between a span of 22 days. Also during a time span where a blockade has been imposed, as well as a time span where a civilian flotilla carrying humanitarian goods was attacked with lethal force. And only in Resolution 1860 does the Security Council even mention the blockade. In Resolution 1850, it's more of a condemnation of Hamas, an affirmation of Annapolis, and a commitment to the peace process. This, of course, stands in marked contrast alongside the Security Council's resolutions on Bosnia and Herzegovina and Somalia, wherein it emphasized the centrality of humanitarian law and invoked its Chapter 7 authority to ensure the delivery of humanitarian relief. The tendency to let politics trump the law is also evident in the treatment of the Gaza flotilla. In the aftermath of Israel's attack on the flotilla to Gaza, the President of the Security Council issued a statement that called for the full implementation of 1850 and 1860 and reiterated that only a political solution would solve the conflict and bring peace to the region. This tone is also reflected by the language of the UN's Assistant Secretary General for Political Affairs, Oscar Fernandez-Taranco, who spoke before the Council and said, quote, "Bloodshed would have been avoided if repeated calls on Israel to end the counterproductive and unacceptable blockade of Gaza had been heeded." Moreover, Taranco emphasized the deleterious impact of Israel's raid on ongoing proximity talks that he said must continue. This language, although seemingly refreshing in an environment where Israel is not subject to any accountability, is actually misguiding to other states. For one, the use of counterproductive and unacceptable as opposed to illegal makes this a political and a moral situation, but not one subject to legal standards, which directly impacts the remedies to treat such crisis. As shown here, if it's illegal, the only requisite treatment is ending the blockade altogether. If it's counterproductive, then the treatment is to reform the blockade to make it more acceptable. And if it's unacceptable, then you ease it until the population is well taken care of, but you continue to use a certain type of force of law that's unacceptable under the laws of occupation. This, unfortunately, mirrors the U.S.'s position as well. So that the Security Council, not surprisingly, I'm sure to this audience, but that the Security Council's position was no more forceful than the U.S.'s position, which held that the siege was untenable because, quote, Gaza has become the symbol in the Arab world of the Israeli treatment of Palestinians, and we have to change that. We need to remove the impulse for the flotillas. The Israelis also realize that it is not sustainable. Worse than that, Israeli officials believe that its easement policies are rehabilitating its relationship to the state's hobbled relationship to the international community. Alam Liad, former Director General of the Israeli Foreign Ministry, explained, quote, Israel eased the boycott meaningfully. Maybe we've scored some points at the UN because Israel revealed some sensitivity to the pressure. In what appears to be a reaction to Israel's diplomatic efforts, the Secretary General's office announced that only land routes and not the sea should be used to deliver aid to Gaza. So in the best case scenario, as concerns the rule of law, the illegal nature of the blockade continues to evade scrutiny. And in the worst case, the UN has implicitly suggested that the blockade is legal by insisting that aid convoys should respect Israel's naval blockade. In both cases, the UN exhibits no resistance to Israel's challenge of the existing legal order. Okay, so for the sake of time, I'll just discuss via the PowerPoint the implications on the UN Security Council as a result of this. First, the UN has left confusion where there should exist clarity regarding the applicable legal order and the appropriate use of force in Gaza. Second, it has provided poor guidance to states that are not fulfilling their obligations pursuant to Common Article 1 of the Geneva Conventions. Common Article 1 imposes a duty upon high contracting parties to uphold the Geneva Conventions, and in this case that would mean that even if the UN fails to apply sanctions and fails to hold Israel to account, that it should take its own measures in the form of sanctions and otherwise in response, but as a result of the Security Council's direction and leadership, even states have failed to uphold this, and in most cases have not even called the blockade illegal, but have also referred to it as counterproductive and unacceptable. And finally, there's an untold impact on the authority afforded to international law in the UN itself. To treat these shortcomings, I make 6 recommendations. Are you interested in the recommendations? Well, I imagine you can guess some of them. But the first is that the Secretary General issue a presidential statement and or the Security Council pass a resolution declaring that the blockade is illegal and a threat to international peace and security. The second, Security Council should invoke Chapter 7 authority to use military force to reconstruct Gaza and or ensure the delivery of humanitarian relief throughout Gaza and or impose sanctions on Israel. Third, that the Security Council affirm the International Court of Justice's advisory opinion on the separation wall, thereby affirming that the only legitimate use of force in Gaza is subject to law enforcement standards. This is critical also because of the U.S.'s own opposition to the ICJ's decision, as evidenced by one of its congressional resolutions condemning it. Although, of course, this would be difficult given that the U.S. is one of the 5 permanent members of the Security Council, and I get to a way to overcome that. But fourth, that the Security Council incorporate international humanitarian law into all of its statements, declarations, letters, speeches, etc. Fifth, that the Secretary General requests that the government of Switzerland, in its capacity as a depository of the Geneva Convention relative to the protection of to the 4th Geneva Convention, okay? Convene a conference of high contracting parties to the 4th Geneva Convention to affirm its applicability to Gaza, as well as discuss measures of enforcement. And finally, 6, to empower the General Assembly to override a Security Council veto by a 2/3 majority vote to enable the UN to be a mechanism for the exercise of international collective will, and not just for the exercise of the Security Council's political prerogative. Thank you.
comprehensive talk, and I'm sure there'll be a lot of questions, in particular the call for revolution in the UN Security Council. But then again, of course, this is the difference between obviously she's coming from a legal side and proposing legal remedies as opposed to a purely political one. Most of us here, certainly myself, even in my own academic writing, the tendency is to be cynical, but from a legal point of view, it is important and interesting always to explore what can be done legally as opposed to simply giving up politically and saying it's not possible, so therefore we don't even start pushing that a little bit, even just for the sake of the principles and the international law. So before we open up to the general audience, I would like to invite, first of all, Professor Khalid Hindawi to give 5-10 minutes worth of response.
5-10 minutes? It's going to be tough even if you stick to the 10 minutes. But, well, first of all, I wanted to thank and congratulate you for, I think, it's very important. Very important and very seriously, thoroughly conducted study. I think you have achieved to analyze critically and clarify the current situation in Gaza with the blockade, the recurrent use of military force, etc. And it's indeed really critical to conduct such serious and precise analysis of situations like the one in Gaza where confusion is deliberately created and maintained as to the facts on the ground, is there a humanitarian crisis or not, or as to the set of international rules that actually applies to the situation. Is it jus ad bellum, jus in bello? Is it international humanitarian law or human rights? And the distinctions between these different bodies of law are blurred as a result, which in turn makes it more difficult to assess the legal virtue of such measures as the blockade. And of course, among that confusion, one of the leading trends is to avoid tackling the legal dimension and to stick to more political assessments. So therefore, your question whether the blockade is simply wrong, counterproductive, or clearly illegal, I think is particularly well chosen because it rightly stresses the crucial aspect and this tendency to avoid condemnation in legal terms. So, scanning Israeli law reviews or contribution of Israeli scholars to the debate on the legal regulation of occupation in Palestine in general, in Gaza in particular, it becomes very clear that beyond the military battle, there is also a battle in the legal field that is going on. There are these attempts that you stress to create confusion as to the specific rules that are applicable. The argument that the rules are not that clear. That also what is labeled as terrorism requires specific rules, given the fact that it's a specific threat, and that international law needs to evolve to adapt to this new kind of threat. One point I wanted to mention is, you mentioned this already in your presentation, that it's the fact that this type of argumentation is not new, and it's also not specific to Gaza. Mm-hmm. We heard the same kind of argument since the beginning of the so-called war on terror, because we have these new threats by terrorist groups, etc. We need new law. We need to go beyond the traditional understanding of self-defense. But actually, even before, if we go back to the Cold War, we already had these kinds of argumentation saying, for example, concerning nuclear weapons. Yes, nuclear weapons are an entirely new type of weapons. You cannot wait to be under attack to actually react and defend yourself. It would be too late. So therefore, again, the scope of self-defense should be broadened. So there have been these attempts for decades now. So what's common behind all those types of argumentations is the fact that there are attempts to restrict the scope of the prohibition to resort to military force in international relations. And basically, they are trying to provide powerful states with legal justifications to be able to actually use this military force instead of systematically trying to peacefully settle disputes. And usually it's combined with the argumentation that, with the idea that negotiations or discussions with these terrorists is anyway possible. So, you know, it's leading nowhere, you don't compromise with terrorists, etc. So considering that context, I really, seems to me that this Gaza blockade, the legal political discourse around it, is one of the recent battles in that conflict about the role played by international law in international relations, and more specifically about the legal regulation of the use of force. So one question may be, why bother ourselves with these legal issues and argumentations that in many cases do not seem, seriously sustainable. But the point is that these debates might have an impact on international law in the long run. So that's the problematical point. There might be an impact on international law if there is insufficient reaction from the side of states, of international actors in general, legal scholars, etc. Because these international rules are not set in stone, and at some point they may evolve if we have an evolution in practice and lack of condemnation in face of recurrent violations. So therefore, it's extremely important to maintain clarity on these legal issues and to repeat, yes, it is legally a situation of occupation in Gaza. Yes, the rules of international humanitarian law do apply. No self-defense cannot be invoked in such a situation. And it's absolutely crucial, I think, as scholars, as students, as decision makers, journalists, people from the civil society, as regular citizens, to work tirelessly on shedding light and clarity on issues like the Gaza blockade, on issues like the use of drones for military strikes in foreign territory, like is currently regularly happening in Pakistan, or these issues that are purposely kept in kind of gray areas in terms of the legal regulation, in terms of their legality. And this paper, your lecture, clearly represents a clear contribution to this endeavor. Now, I just wanted to add a few comments on the question of the role of the United Nations and the UN Security Council in that battle. So you stressed that, of course, the response of the UN Security Council has been inadequate, that the Council has failed to uphold the rule of law, and in your paper you make, if I understood right, you make that move to say, well, because of that lack of appropriate response from the UN Security Council, it had an influence on states, and that most states have followed the lead of the Council and mirrored this politicized approach. And you're right, you stress the discrepancies, of course, between UN Security Council actions in reaction to some humanitarian crises and the lack of any reaction in the case of Gaza, or really man-made humanitarian crisis. One could also act, I've been working on Iraq for several years, one could also act, the huge discrepancy if you think of these sanctions that were applied in Iraq for more than a decade, creating a devastating humanitarian crisis, causing the death of several hundred of thousands of people, and the author, or the body that was behind these economic sanctions was the Security Council itself. So I tend to have, you worry particularly about what's going to be the impact of that selectivity in the approach of the UN Security Council on international law, and I tend to have here a slightly different view. And as a consequence, I would be a bit less worried about the potential impact of UN Security Council failure to uphold the rule of law. Because one should not forget that the UN Security Council is a political body, given the voting procedures, the veto power, etc. So it's been only clear from the beginning that the Council is only able to react, to enforce law, and adopt coercive measures if necessary when none of its permanent members or their close allies are concerned. And this has been the case for 65 years. So I think it's not surprising that there is no clear condemnation of what's happening in Gaza, just as nobody was surprised that the Security Council was not able to clearly condemn the invasion of Iraq conducted by 2 of its permanent members. So let's not give the UN Security Council too much of an impact on international law, given that political situation. And let's not expect too much from the UN Security Council as well. What's more problematical to me is the lack of condemnation of the situation by many states. Because in the end, states are the major contributors to the creation, the modification of international rules. So their practice may have an impact, more, I think, than the one of the UN Security Council. So I would suggest that in terms of advocacy or focus, that the focus should not be so much on trying to promote a clear condemnation from the side of the UN Security Council, but more on states. Because this is from the side of the state when this is where the absence of condemnation, reaction may endanger international law and may have a real negative impact. As far as the UN Security Council is concerned, I think the real impact of this selectivity in the enforcement of international law is not so much the impact on rules of international law, but on the legitimacy of the UN Security Council and on the UN in general. I think it's particularly clear in the Middle East, where I guess almost nobody still have any kind of trust or hope in the UN Security Council. So the Security Council is just continuing to lose any kind of credibility. So my questions would be, as far as international law is concerned, do you really believe that one should focus its attention and efforts on the UN Security Council and expect much, given the composition of the way the Council works? Or what about my suggestion to shift the focus, the attention, the advocacy on states or groups of states as the European Union? So focus the advocacy at the national level more. And in terms of the credibility of the UN, this is the $1 million question, I guess. Do you see ways for the United Nations, UN Security Council in particular, to regain some of its lost credibility in the Middle East? Because it's so damaged that I don't know. How could trust be built again? Do you see this as feasible? Thank you.
I'd like to invite Badil, who's head of Human Rights Watch here in Lebanon, for a brief intervention as well.
Thank you. It's definitely a very interesting paper to read and the presentation to listen to. And I actually want to start by agreeing on the premise. I mean, over the last 10 years, and specifically after 9/11, we've clearly seen more and more attempts of reinterpreting IHL, mostly by states which want to reduce the protection that international humanitarian law, I'll use IHL now, to reduce the protection that these laws give to civilians and other people. I mean, at the forefront of this battle have definitely been the US and Israel, but they haven't been the only ones, but maybe they're the more sophisticated players. And now there's a whole industry, and there's a term called lawfare, about this sort of battle that is going on concepts, on notions. And we've seen it, for example, in the infamously called global war on terror, about the status that combatants have. Are they prisoners of war? The US created this new category called enemy combatants. And I'm sorry for the non-lawyers, these are, each term, there's probably hundreds of papers now, and Noura can probably say more about that than myself, but people arguing about these things because they matter. These legal categories come with them specific rights, specific duties on states, and they matter. There's been a huge battle also on the two main principles of international humanitarian law, the principle of distinction, and specifically the question, who is a civilian? Who is a civilian today in the context of Lebanon? Is the woman baking bread for Hezbollah fighter in southern Lebanon a civilian, yes or no? Again, huge battle going on about that. And what does effective contribution to the battle mean in such context? And finally, even on the notion of proportionality, the second element of protection within IHL has also come under a lot of attack. The drone attack. If you kill a Taliban commander, but you kill with him 15 members of his family, is that legal or illegal? These questions are being debated, and I think there have been really two factors that are driving this process. One is the fact that we're moving from a world of sort of traditional warfare to more and more asymmetrical warfare. And you see states unwilling to have their hands tied, and they want to push the battlefield to their area. This can be from a realpolitik perspective. We can understand that states are always trying to sort of write the rule book in a way that helps them. And two, this sort of creation of this term called terrorism and all the various legal, again, trying to create a rule book that allows states to go and fight these groups without having to respect traditional rules. And their main argument is, well, these groups don't fight it, so why should we have our hands tied if they don't have their hands tied? And I think it's great to see, and thank you, Noura, for doing that, because so far it's been, most of the time we tend to read papers trying to limit the protection, and smart lawyers trying to find ways to give states more and more power. And it's rare, but thank you, to actually read more and more papers trying to say, wait a minute, we need to push back. And I think this is very important. This is something that this paper sets out to do, and I think it's a great contribution. Now, I work for a human rights group. We've also been trying with other human rights groups to push back. And I'll give my perspective in sort of three sets of comments, and I'll sort of try to build on your question. Is it wrong or is it illegal? And my first set of comments is, it is illegal, but in what way? And this goes to, I think, something you try to address in your paper. Various groups from Human Rights Watch, Amnesty International, and others, and UN Special Rapporteurs have actually said the blockade is illegal. It's very clear. The argument we've used is probably the more traditional argument of saying this amounts to collective punishment. Collective punishment does not distinguish between people. And because it's collective punishment, it is illegal under general principles of international humanitarian law. I think, Noura, here you take us to another, and if I understand correctly your argument, you're sort of taking it to another element, saying, even if it was a smarter embargo regime, blockade regime, even all these things, it would still be illegal because you're sort of playing on a different playing field. You're sort of saying, we apply the laws of occupation, the laws of occupation, blockade is an act of war, you cannot declare war on an area of occupation. I think this is very important, and it actually got me thinking, and I shared it with a couple of colleagues of mine in our legal department to discuss it. Their answer was, it's a very smart argument, but what does it give us? And I think this is my first set of critique, which is, how does your approach help us protect civilians more? Because, and just for everyone here who's not sort of an international humanitarian law specialist, these are a very cynical set of laws. So if we were to accept Noura's argument, what the Israelis might change and say, we're going to open 100 Israeli police stations in Gaza today, and that is legal for us to do under the occupation laws. And anytime we see someone smuggling anything inside, we will detain them under occupation laws. And under the regime of occupation, they would be doing legal things. And that doesn't really help us, or at least we won't feel that we're getting justice. And I think for me, the first, question I have for you is, what does the approach you propose? So sort of saying, forget about these human rights groups, these rapporteurs that are trying to play the game of distinction, proportionality, proportionality, spending all this money going on the ground to prove case or not that this was a violation. The act in and of itself is illegal based on legal terms. So how does that help us protect? With the specific idea that the Israelis can say, fine, you want us to apply occupation? We'll be happy to apply occupation. And they'll do this and they'll decide that they want to feed, like they've done up until 2005. And by the way, just as a footnote, Human Rights Watch does consider that Israel is an occupying power, just to be clear. But I think you're right, you raised an important point, but I'm not sure how it helps us. The second point, which is, again, playing on your word, is it illegal or wrong, is the critique of saying, it is illegal, so what? And this is something we get a lot as human rights groups, saying, you spent all this time and effort to prove that this particular act was illegal, so what? No one's getting punished for it. What matters today is whether it's wrong or not, because we're in the battle of public opinion. Now, you won't hear me saying that, but I'm raising that critique because this is a critique we often face, which is saying, who cares if this is wrong, or sorry, if this is illegal, since you don't have today a tribunal that would actually deem that person a war criminal and send them to jail. It's a difficult critique. My answer has always been, and this it is illegal and wrong, and the fact that it's wrong, the fact that it's illegal, it's making it more and more wrong. So it's sort of legalism being used in the broader battle for legitimacy. For lawyers, this is not a particularly satisfying answer because we believe in laws, we want to see justice, we want to see people in court. But I think this has been, one of the biggest challenges because let's face it, international humanitarian law has very weak enforcement mechanisms. And the one, a new enforcement mechanism, the International Criminal Court, hasn't been ratified in this part of the world. And so it's not there. And this is raising, this sort of legality and wrongness, and you sort of realize, and I've noticed that, I had the experience of working on violations of laws of war during the Lebanon War. People weren't interested in the nitty-gritty legalistic analysis of what you could prove. They were interested in sort of the slogan because they were fighting, the broader battle of legitimacy and wrongness. And I think that, sending it back to you, I agree with you. It is not. It's wrong and it's illegal. It's important to kind of emphasize its illegal part, but there's a challenge on all of us, lawyers, academics working in this field, to make it more and more relevant to people to say, you know what, it's illegal. Because often when you tell people, they say, oh, but they it doesn't really help. And the third set of questions is, building, is it illegal or it's wrong? Well, my question is, who says so? And you decided to focus on the UN Security Council. And this is probably the part that I found, from my perspective, I'll be very blunt, the least interesting or persuasive. Because I agree, we all know how politicized the Security Council is. We all know how it's mission impossible to reform it, and there have been a lot of emerging powers trying to reform it for a long time. And we all know what it means to have the U.S. with a veto power. And by the way, just to sort of get to that point in a second. So, do I think, you have a basis of saying the Security Council, and I agree with your point, is the only body to have an enforcement mechanism. Therefore, we should keep the battle at the level of the Security Council. On paper, yes. Are there probably more interesting things going on today, specifically around Gaza, that probably warrant more interest to see how that could interplay? My answer is yes. And specifically, I'm talking about the Goldstone report, the role of the UN Human Rights Council, and what possible, how these various UN institutions can maybe interact or be made to interact together. So slowly, we don't just see the Human Rights Council as something that can say, oh, this is wrong or this is illegal, but it somehow feeds back into an enforcement mechanism. And here, I'll conclude. I just want to say a couple of things. One, I'll be interested to hear your thoughts about how you've seen the impact of the Goldstone report, the debates that have been going on. Again, on this notion of what is legal or illegal, because I think it has had an impact. If we only measure it, and it's on a superficial level, but how sort of the Israelis have been forced to conduct some investigations. They're not serious at all, but they're probably slightly more serious than what they've done before, even though they're just, trying people who stole credit cards from people's homes. But, secondly, and how could that mechanism, in terms of recommendations, be made more effective? Because I think here, and we have to be very aware of it, one of the reasons why this debate is not really getting off the ground or getting off the Human Rights Council is partially because of the negative role played by the Palestinian Authority. And we don't discuss that. I think it's very important. There has been, we probably all remember the outrage that happened when the Palestinian authorities decided to basically kill the Goldstone Report the first time around, the Human Rights Council. Well, you know what? They just killed it again, like a few weeks ago, by sort of saying, okay, let's sit on it and read the report. Why is that? Because they, the main actors, we can say about legitimacy and so forth, but the main people who are supposed to be concerned about it are more interested in playing the political game of the peace process as opposed to push for real accountability. And I think that is a real great weakness, and I think it would be great to discuss some of those dynamics, because the issue, yes, it's with the Security Council, but it's also sort of at the other level. And finally, just in terms of comparison, because it is true, the Security Council as a political body and as sort of a reflection of sort of the U.S. power in it and the alliance that the U.S. has with Israel has been very biased in this part of the world. But it's also been biased other places as well. And I think it would gain, one of the hardest part, I feel, is while we sort of in the Middle East always cry, we're getting injustice, which I think is true, there hasn't been much of an effort to build with other areas that also feel left out. How many Security Council resolutions were there on Sri Lanka? What happened there? And I think it's important to build these cross linkages because it will make the coalition stronger. But again, thank you very much for a very interesting paper. And
thank you everybody. Thank you, Naeem, and thank you everybody for being patient. With 3 lawyers here, it's a very dense conversation. Before I give Noura the chance to respond to the discussants directly, I'd like to open up for one round of questions, and then she'll be able to answer both the discussants and this first round of questions to get early next moment. So if you raise your hand, and if you have any questions. And a single question?
it's the Latin that killed everyone.
My first, I'm not a lawyer.
Okay, so let's wait for the microphone. And identify yourself, please.
Okay, Okay, my question, I'm obviously not a lawyer, so my question is more related to customary law. Who decides what the trends are in customary law? Like, you were talking about taking it from the Security Council to the General Assembly, and the discussant suggested letting member states make their own statements about whether it's legal or not, and based on that. But how is that weighted? Because the Security Council is a representation of member states, but it's weighted based on the 5 permanent powers. If you go to the General Assembly, it's all member states, but it's not weighted at all. So they're equal. So are certain states more important than others, or are we just taking it across the board? How is that decided?
Another question? Yeah. Maybe the best students in the back, then, and then one last.
Hi, Maya Mukdashi. Stand up. Maya Mukdashi. I'm a PhD candidate, actually researching matters. I'm a legal anthropologist. So I have a few questions. First of all, I noticed in all your presentations there's a separation between law and politics, so that then you say this becomes politicized, whereas the history of law is linked to the history. Obviously, they're cross-polluting each other. And particularly the history of international law could be read as the political history of Europe, beginning all the way back to the idea of just war, and most recently, obviously, the Jewish Holocaust and the aftermath of World War II, which actually leads to so many of these conventions. So how could we maybe complicate this idea that is maybe we use it strategically because you have to separate in order to function, but actually when we make that separation, we may be doing more harm than good. That would be my first comment. The other comment is when it comes to applying occupation law. For example, the idea that Nadim was saying in terms of Palestine, well, what if Israel says, hey, okay, we're occupying, here you go, here's these 100, 200 police stations. Would that make the legal case for resistance stronger? Because you have now an actually physically occupying force, which is then open to resistance according to that same international human rights law. And that's all.
Okay, thank you. One last question, and we'll let Noura.
My name is Susan Nicholson. I'm an attorney from the United States. I have a question about your sixth recommendation. Could you talk more about it, how it would work, and whether it would lead to some enforcement power?
That's my favorite question. Sorry to Maya and Nadim and Colin. But let me start from an overarching. Thank you very much to the discussants for very incisive comments and to the audience. And I want to start from an overarching, what seems to be a tension that I might have been unintentionally created, which is to do this analysis and yet perhaps implicitly suggest that this was then the requisite course to justice. And it's not. And so just to clarify up front that my emphasis on the law and on the Security Council was not somewhat of a strategic paper on advocacy. To the contrary, it was very much an analysis, a scholarly analysis around these issues. Why? Because there are some things that are very obvious that we live in our day-to-day, and here I'll bring an example from the United States, and we'll just to consider the example of an enduring legacy of structural racism against African Americans and other minorities that many argue is not relevant because slavery has ended, Jim Crow has ended, Native American treaties with Native Americans have now been resolved and they're given independent jurisdiction over territories and reservations. And so therefore we're a colorblind society and we need not have these discussions. And in fact, if you have the discussion, you're engaging in reverse discrimination. And which brings me to my concern with the Security Council. I too find the Security Council highly irrelevant, and perhaps the seventh recommendation would be like, just get rid of it. just get, engage in Robert's rules and have everybody in the chamber halls actually stop with the diplomatic niceties or engage in more of them in order to come to these resolutions by way of majority vote, and if they're so successful, by way of consensus. And so, but the purpose of looking at the Security Council is precisely because it's the highest level of enforcement authority, and therefore is the most dangerous. And it's the most dangerous in setting trends, and it's the most dangerous in waging war on civilian populations, as Coralie significantly mentioned was the case during the UN sanctions regime against Iraq. So then there were, which brings me to Maya's point about really the inextricability of politics and law. And I also apologize and here I probably did this more on purpose because it is intended for a legal audience to isolate the law as a factor, but law is politics. Law is politics. And very, very much the history of law is one that's used to either legitimize privilege or to somehow perpetuate those practices which are now considered insidious by a civilian society. And so I don't know that happened in this conversation, but I thought that it was necessary, again, to isolate them to get to perhaps what may be most obvious, which is to bring me now to theory of social change, and something that Nadim focused on, much more interesting spaces to be able to have these discussions as opposed to the UN Security Council in this case. You're absolutely right. And yet I would not discredit a single space of advocacy. Whether it be the US Congress, which we can go into an entire discussion, 535 members from the Senate and the House side that literally, across the board, have to pledge some allegiance to Israel's security in order to be elected to government. I mean, this is clearly a battleground that should be neglected if we were to say that it's useless and therefore irrelevant and everybody knows what it does. But we shouldn't neglect it because it becomes a self-perpetuating cycle where the gap between advocacy and relevance widens. But the less there is said about human rights issues in the Arab world, on the Hill, for example, because of the disavowal of Palestine and this kind of deference to Israel, the more that this Israeli voice becomes the singular voice. And so it might be a drop in the bucket, but it's a necessary one. And it's the least satisfying one, in the same way that the courtroom, however futile and however incremental as critical legal theory scholars may argue, it still is necessary because those incremental gains eventually lead to something bigger. At the same time, simultaneously, that there is a broad-based approach to delegitimize the entire process. So I definitely don't intend to make any of these mutually exclusive. Let me move to this question about the question of what's the point of saying that this is illegal from the outset? And the point of saying that it's illegal from the outset is not because, and I think you're drawing here on the theory of law, that if there's a right, there's the redress, right? There's a grievance, and you can redress that violation. In this case, the redress is obvious, however unrealistic, which is if it's illegal, it must end. Nothing short of ending it would suffice. Now that brings us to the question, well then would occupation suffice? Perhaps not, but at least the controversy over ending the occupation would no longer be a space of argument about whether or not there is an occupation or there is not, whereas some people have begun to say that this situation is no longer one of occupation, but it's also not a sovereign, Gaza is not a sovereign state, it's somewhere in between. Well, that somewhere in between is a complete gray zone where it's a legal black hole. There's absolutely nothing to be done but to participate in some sort of fight against Israel itself and those chambers of power that legitimize this. And then here we bring to the question about the legitimacy and the purpose of legitimacy and a crisis in legitimacy. That which is considered illegitimate has very little force. You not obeying a law, and here we come to civil disobedience, actually makes that law less relevant. And in the case of Israel, legitimacy is at the crux of its project because it has very little else beyond its moral legitimacy and hence the perpetuation of a David versus Goliath syndrome. And so this is part of where other tactics like boycott, divestment, and sanctions also come into play, and it's really a question of legitimacy, at least on that sphere, which is the extra kind of battle against it. And so I know I haven't, and this is very relevant, just this legitimacy question is very relevant precisely for what you raised, Nadim, around asymmetric warfare. In asymmetric warfare, the technologically endowed belligerent, whether it be the US in the Vietnam War, or it be Israel against Gaza, or against Hezbollah and all of Lebanon, the battle is no longer about who's going to win militarily, because it's kind of obvious who can pulverize who, even though in some cases that's not the outcome. But that's not necessarily where the battle takes place. The battle does actually take place, as was the case in the Vietnam War, in kind of the moral public realm. And so, hence, legitimacy becomes more acute and necessary in asymmetric warfare, and perhaps it's something to be explored in greater detail. Just on the technical question about customary law, on this question specifically, this would probably can do a second chapter on customary law. And actually that's where I started, and I went to the Security Council because it was much more discreet. You can hold on to it, you can look at it. Customary law, there's a few methods of looking at what changes customary law, how you balance opinional juris versus state practice, what becomes more relevant than the other in certain situations, which states participate, do those states have moral legitimacy, how they're viewed. It's quite an arduous task to measure this. And it's really not to be taken for granted that the participation of a superpower in this equation has a lot to do with the strength of customary law. As we've seen now, Israel may have started this trend with drones and targeted assassinations, but now the US is participating in its own targeted assassination in Yemen against Al-Awaki, for example. And so what's the role then? The question becomes, if a superpower participates in this violation, does that alone suffice to then shift international law? If not, how many other states, which states, and so on and so forth, and is it enough in practice, or is it enough in thought and writing? And that's, I wish, maybe I will. Maybe if IFI is interested, or I do it for myself, it would be another chapter to explore, certainly.
Okay.
Lawyer Nicholson asked a very good question about the recommendation, the enforcement.
Oh yes, about the 2/3. So there's my one answer to this, which is it's a very hopeful recommendation. There's very little way to enforce it. There's one rule in the UN Charter that's afforded to the General Assembly, which will actually counter that. They can't necessarily challenge the Security Council, but they can bring issues to the Security Council and cases where they can circumvent it altogether, as was the case in the reference of the annexation wall to the ICJ, for example. But whether or not the General Assembly will have a 2/3 veto power really depends on. It's a question of power in politics. And so there's no legal, I think, answer to that, because it will become a complete battle between those with the privilege against those without it, and whether or not, for example, in the middle of such a process, the United States offers loan guarantees to some of those states in order to have them back off so that they don't participate in the battle, or otherwise threaten them with violence and so on and so forth, which is very relevant. So this week, and some argue, as Coralie mentioned, am I pronouncing it correctly? Yeah. Okay. I just realized I might have known the whole time. But some argue that from its outset, the UN is flawed. The UN in its creation is flawed, and there's nothing you can do to fix it. Sorry.
Yeah, I just wanted to follow up on a point I think Maya raised it today. This is something we hear a lot. Sort of the cynicism of the law, and that basically law is just politics by any other means, so why even bother? And I'm not talking here just from a job security perspective for myself, but I think it's important to recognize that there is a space. It doesn't fill the whole space, but there is a space for using the law, for applying the law, and particularly when it comes to IHL and to armed conflict. IHL is not gonna create an independent Palestinian state. That's not what it's going to do. IHL is not going to, come to the, help a rightful cause. But what it would do, and what it could do, and we can make it even more effective, is when there is an armed conflict, protect civilians a bit better. Now, I can understand the critique that is done that this is in a way just putting a band-aid on a situation, and in some ways just make it last longer. I actually tend to disagree with this position. If we look at the reduction in terms of casualties, they're still horrible. But how states, even if they continue breaching this law time and time again, but at least they try a bit to reduce it. I think it has an impact, maybe marginal, but I think it's important because we hear that all the time. This sort of uber cynical point of view. And yes, we should be cynical, but in a sort of proactive way to try to enforce it. But I don't think we should sort of throw it all out and say, well, it's just politics by any other way, because at that point, it doesn't balance the field, but it does sort of help protect civilians. And I think that's important, especially when you're sort of on the weaker side. It's just my 2 cents. I know it's controversial.
Maybe just one comment to add on that. Also, not to neglect the fact, yes, of course, international law and international politics are highly connected. But not to forget that, well, the set of international rules that we have are the result of political processes. And they are something else than only practice that is not binding. There is another, an additional dimension to it. Even though, of course, it's the rules we have are the result of politics. But it's something, it's important to keep that distinction because the body of rules that we have, even though not perfect at all, and even keeping in mind the lack of enforcement, on the very scarce ways to actually enforce international law, still is a framework that is the result of lengthy negotiations and attempts to try to have a better framework for international politics.
I just want to say one last thing. As Karim mentioned in the beginning, I think I straddle the worlds of scholarship and activism. So in loyalty to that activist spirit, I definitely don't want to discourage anyone by my last statement about the UN. Those spaces may be irrelevant, but just as the law may be a product of political processes, so is the legitimacy of the law and the legitimacy of state the process of the support of people. And so there's a lot to be said for people power, especially in collective ways, that should never be dismissed, because absent what that collective can do, these states, these laws, these multilateral organizations altogether are irrelevant. And so never, I feel that the feeling of ever being trampled is really giving yourself too little credit to the potential of what we can do. So I'm there.
Thank you to everybody. Too cynical about the UN and others, and if you're interested, at Issam Institute there is an initiative. It's called the UN in the Middle East Research Initiative, which is part of what this series is about. There's going to be a couple of research projects that are going to be launched, more lecture series. So if you are interested in the UN, in particular in the UN and international law in this region, please do follow. We'll find this up on the website, and I'm sure you'll be seeing things in circulars. So with that in mind, before I forget, I'd like very much to thank the IFI staff that put this together. Zaki Boulis for the communication manager, may have left already, Sarine Karakajian is the administrative manager, and mostly Ramzi Fouri who put this all together and is partly in charge of this of the UN and Middle East Research Initiative, so thank you to them all. And finally, thank you to the discussants, to Nadeem and to Coralie for their very insightful comments. And as well, of course, to Noura, and thank you very much all for coming.